Welcome to Got Invention Radio. I'm your host, Brian Freed, and we have Marty Robbins. He's from an IP firm in Chicago called Fischer Broyles. Marty, welcome to the show.
Thank you very much, Brian. It's an honor to participate.
Great. Marty, there's so many inventors that come to me and I know call up intellectual property attorneys and agents and ask people all over the place. They come up with this great idea for an app and they're trying to figure out how to protect it. So today's show, we'd like to focus on that, and we really appreciate you coming to the show and being a part of it. Marty, before we get started, tell us a little bit about yourself and about your firm, Fischer Broyles.
Sure. We are a national law firm of about 80 partners, and interestingly enough, while we have significant practices in all business law areas, we emphasize intellectual property, and we have 8 registered patent attorneys in our offices throughout the country, along with partners in a number of other IP specialties. Our firm keeps its overhead very low. We do not have salaried junior attorneys. Everyone at the firm is a partner. We have essentially no real estate, so we provide high-quality service for a fraction of the cost of other substantial firms who work in this field.
Great. And I know that you have several offices around the country, and then also if you could tell us a little bit about what you do.
I personally combine a corporate practice with an IP practice. I've been in practice for 34 years now. Started as a more traditional corporate lawyer shortly after I graduated from Harvard Law School. I worked for a couple of traditional large firms, and over time my practice has gravitated to a combination of traditional corporate work and IP work. In fact, I teach at DePaul Law School in Chicago, teach a course called IP for Corporate Transactional Lawyers, so I think it's fair to say I have a foot in both camps. I do a fair amount of work involving the use and exploitation of intellectual property, particularly development and licensing agreements.
Okay. Sounds like you do a good amount there, and you're the right guy to speak to about this. Before we get started, Marty, and we were talking about this, to kind of go over the overview of the landscape of the way that you can protect your intellectual property. Now, before even we go to that point, there's so many people out there that are just unsure of if they need intellectual property protection or not. And we're saying intellectual property a couple times. We're talking about what you hear, provisional patents, copyrights, trademarks, utility patents, trade secrets. There's a whole bunch of intellectual property terms out there. So before even that, Marty, there's so many people that are just trying to figure out, do I need intellectual property protection or not? It's too costly for me. Maybe I should just skip it. How do you feel about that?
Completely disagree. And I think it's important to note that intellectual property protection is far from a monolithic term. As you've indicated, there are different strategies that can be used in different types of IP protection. And in virtually every case, there's some strategy, some technique that is appropriate for the individual in question. It's definitely not a situation where if you have to ask, you can't afford it. Even traditional patent protection is usually a lot less than people would anticipate. People read about the Apple and Samsung patent wars that have clearly cost hundreds of millions of dollars. That is most certainly an outlier. In the vast, overwhelming majority of cases, people can get meaningful IP protection for a tiny fraction of that amount. Now, what does IP protection encompass? Well, as you've mentioned, we start with patents, and there's traditional patents, which are essentially a 20-year monopoly defined by the patent specifics, typically known as claims. And there's also a provisional patent application that is kind of the beginning of the patenting process that's used for the companies you've described and the inventors you've described that want to test the market and see if there's commercial demand, commercial viability for what they have in mind. It allows them to start the process, get some modicum of exclusivity, and then determine if there's sufficient demand to proceed with the full, more costly patent application.
Okay, that's the
Then there are
provisional.
trademarks, which are identifying marks or phrases.
Mm-hmm.
There are copyrights, which are expressions of ideas in both a traditional fixed format and a digital format. Then there are trade secrets that are essentially confidential materials that have actual or potential economic value. With trademarks and copyrights, while technically a governmental filing is not required, it is highly advisable to pursue such filings. They are not particularly costly. In the vast majority of cases, much cheaper than patent protection. And if one needs to enforce their rights, it is infinitely preferable to have a governmental filing than not have it. Trade secrets are more informal. There certainly should be efforts to create information that is, or to create and maintain the secrecy of the information in question. Typically, that's handled with private agreements and policies. That's often a good alternative to patent protection. One cannot get a patent for everything. Where one can't afford or cannot get a patent, trade secret protection is typically a very good strategy to pursue.
Okay. Marty, that was a great overview. Let's just kind of focus and get the inventors just some quick information on a provisional patent, the way you described it. It's a filing date that can hold your place for 1 year while you're exploring the options out there before you file what's called a utility patent or right?
A design patent.
Or a design patent, I've heard that all you have to do is just really file the design patent. It doesn't make sense to file a provisional patent before a design patent. Is that right?
There are different schools of thought. If nothing else, the provisional patent is almost invariably cheaper than the design patent or utility patent application, but there are different schools of thought that are utilized by different practitioners.
Okay. And a design patent is really, it's ornamental. So if I make a circle and I put some lines on the outside of the circle and somebody else changes that design, they have a right to get a design patent also. Is that right?
I think it's a little bit difficult to say for sure in this context. I think that's where trademark protection may be preferable. Perhaps it ought to augment the design patent protection. I think there's a place for both in a particular situation. But
okay.
Certainly protecting the identifying mark is where trademark protection comes into play.
Okay, so basically when something like that happens, it could be where you have a design patent, but you also have a trademark that's describing what's actually being covered. And the trademark you would file in a class of goods that you're potentially bringing this to market with. And that between both of them, basically what you're doing, Marty, is you're building up assets to be able to protect yourself, right?
Most definitely, Brian. Certainly those assets come into play in a big way when one looks for external financing or when one seeks to sell their company.
Okay.
Your reference to assets is very well taken, both in an accounting sense and a real economic sense.
Now, we were talking about the cost. You know, you telling me that it doesn't cost much may be different to somebody else. We don't know. It's all relative to what the actual cost is. But there's so many people, Marty, that say, I want to just protect myself by just filing something on my own. I don't want to pay an attorney. It costs too much. What do you tell people when they say that?
I tell them a few things. One is the old maxim, you get what you pay for. Two is, would you say that with respect to medical treatment for yourself and your family? Would you just try and obtain the cheapest medical treatment, just buy a book someplace and try and treat your own or your family's medical situation. 3, I would say that particularly today, given the massive changes we've seen in the IP landscape over the last few years with the America Invents Act and several major court cases that have been handed down by the Supreme Court, it's absolutely essential to have someone who can pursue the optimal type of protection for you and get you some protection today.
Okay. Marty,
the environment has changed drastically. And then 4, the costs are not that huge. Even for a traditional patent, typically you're looking at low 5 figures, say 10 to 20,000, and things scale down from there. That's obviously not a guarantee of anything, but it's just a ballpark number.
Okay. Me as an inventor, Marty, I've been involved in the intellectual property world. And when I come up with an idea, I like to do a patent search, make sure that my intellectual property is not out there already and I don't infringe on somebody else's patent. Or I also want to protect myself when I'm going to potentially license a product or idea. I want to make sure that I have some kind of protection before I present and bring it around and go to trade shows and start speaking to people about it. So I always try to get some sort of IP before I present my idea. And when you're coming up with an idea, it's really, you're putting yourself in business. And I know Got Invention listeners, you hear this quite often. You want to be able to protect yourself. So you want to do it right. And when you're doing your research and development, you want to kind of go through the process if you have a chance to get it. Now, I understand that as you're going through the process, there's costs involved. But again, you're starting a business, and depending on which route you want to go, whether you're manufacturing or licensing, which licensing means that you're going to go to somebody that has manufacturing capability, whether on their own or a third-party resource, and they also have distribution, which they're handling on their own or having sales reps, and you collect what's called a royalty. So there's many different conversations that go on about if you should have intellectual property or not, and how much it costs and how much it doesn't cost, and all these different variables. But if you do, in my opinion, if you do have an opportunity to protect your idea to some level, definitely take advantage of it. And like what Marty was saying, you want to hire a specialist to do it. It's possible to do it yourself, but when you're going to a company that you're looking to license your idea with, and they go to their legal department and they're looking at what you did, you better hope you do it right. Otherwise, they're not going to work with you. They'll just do it themselves. They will see that you've done some kind of professional handling with an IP attorney or agent, that they'll know that they'll have a little bit more of a level of comfort before they would move forward, let's say, with a licensing agreement. Sound right, Marty?
Yes, Brian, that's absolutely right. And certainly in all cases, when people are at the exploratory stage, it makes sense to put in place with other parties with whom they discuss their idea and its proposed exploitation some sort of non-disclosure and invention acknowledgement or assignment agreement where the other party acknowledges that they're receiving confidential material, that there is an expectation of payment for it, and that the material has originated with the person who is presenting that particular material.
Okay.
It at least gives you a leg up in further discussions.
Okay, so let's make this really simple for the inventors. So when you have this idea, you want to be able to present it. Maybe you filed a provisional patent, which is a patent pending. It's not a patent. It's just a filing date. You'd be able to present it that way. You also have an option or of a non-disclosure agreement, like Marty mentioned. And the non-disclosure agreement, basically, what's really in that, Marty, in a nutshell?
Typically two things. One is the recipient agreeing that they will not utilize or pass on the subject matter that is being provided to them, and also their acknowledgement that all IP rights are owned by the party presenting that material. There are different variations, but most of them contain those two fundamental elements.
Okay, and what about a